Hey, everybody, and welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, like we are each and every Thursday night, where we do this live Q&A, where we talk about all things debt-related, whether it's bankruptcy, debt collection lawsuits, wage garnishment, or all those other horrible things. We talk about how to deal with them, how to put a plan together, and how to put that thing in the rearview mirror and get those things behind you. Again, my name is John Skiba. I am an attorney in the state of Arizona. I do bankruptcy, and I also do what I call consumer protection. Represent people who are being sued by debt collectors, deal with wage garnishments, all that kind of stuff. So the reason why I put together this YouTube channel, and gosh, I was looking, I think I have over 700 videos. I've been doing this for almost a decade, is really to provide information to people because, there's some simple things you can do if you're facing, serious debt issues, whether it's a collection lawsuit or you need to file bankruptcy. I always say we go to the worst place imaginable, in our mind as far as what's going to happen with all these debt issues, when in reality, sometimes just simple steps can help you to avoid a lot of pain and to eliminate the debt and, just really deal with it overall. So the way that we do it, if you are watching on YouTube or Facebook, go ahead and put a question if you have one in the chat section or comments on Facebook. I'll put it up on the screen and we'll talk about it. I did, like I do each and every week, I would go to the comment section over on the channel and I try to address some questions that I think have some just overall applicability that I think can help out. And one of those is this one, kind of talking about some little steps you can do to deal with debt issues. This person said, is it possible to negotiate with a credit card before they sell it for less? They say, I'm so behind that it would be thousands to bring current with all the extra fees that they've assigned. So, this one, and the answer is yes to this. It's possible to negotiate at any time. Some people ask me, can you negotiate after they file a lawsuit? Yes. I've had settlements happen literally standing outside the courtroom as we're getting ready to walk in for a trial after fighting this thing out for years. So you can absolutely do that. So the normal collection cycle, again, most creditors, all creditors, I should say this, all creditors, they will do internal collections for about 6 months, 180 days, of no payments. Once it's been 180 days with no payments, by law, they're required to charge it off. And the charge off again means that, it's an internal really tax classification for them. They're counting as a loss on their books. They can still collect on it. And what a lot of them do is they'll sell it to a junk debt buyer to purchase it. So that's what this person was referencing. Can you negotiate before they charge it off and sell it to somebody else? I always say, particularly, when you get around that 4 to 5 months with no payments, that's when it's heading towards charge off. They lose big time when the account's charged off. If you're dealing with like a Citibank credit card or Synchrony, when they sell it to a debt buyer, they're selling it anywhere from 2 to 3 cents to 10 cents on the dollar. So they lose out on quite a bit of money. So they want to keep you current. They want you to be a customer going forward. So I always say it never hurts to reach out and just see what they offer. You might be surprised, particularly as it relates to, like you were saying, all those extra fees. Ask them to eliminate the fees and some interest. The worst they're going to say is no, but you may be surprised. In a lot of the situations, I see this with debit cards too. We don't see it as much anymore with the overdraft fees, but they used to charge, all these overdraft fees. I would always counsel clients, go ask them to waive those. Same thing with a credit card. Go in and ask them to waive it. It's their card. They can do what they want. And I can't tell you how many times I've seen that happen. A client calls up, just says, hey, you know what? I want to bring this current, but there's hundreds of dollars of fees that are past due. Can you waive those and help me to bring this thing current? And you'd be surprised. A lot of times they'll say, absolutely. They have a plan. They want you to pay. I always say this. They want money. You're offering money. There's got to be some kind of middle ground that can be reached, whether it's at this early stage or whether it's at, even with litigation. So, all right. Another question was, this person said, can you file a motion to compel arbitration if you've already filed your answer? So if you've been sued by a debt collector, you have a certain time period, after they serve you with a complaint and the summons to file a written answer with the court. In Arizona, where I practice, it's 20 days. Some jurisdictions are 30. I've seen it as short as 45 or 15, I should say. And if there is an arbitration clause in the terms and conditions, and you want to have the case submitted to private arbitration rather than go through the court process, you can file a motion to compel arbitration. Now, you can do that instead of your answer in a lot of jurisdictions, but if you filed your answer, it's completely fine to do it. The only little bit of caution I would give you is you need to go back look at the arbitration clause and see if there's any time frame limitations. Most arbitration clauses that I've seen allow you to file and request arbitration all the way up till trial, or if a judgment's been entered, summary judgment. So my recommendation, though, is don't delay it. I've seen some judges, if you wait too long, they're going to be more likely to deny it. I don't think legally they should be doing that. But my recommendation is, if you filed an answer, even if it's been a couple of months, go ahead and file the motion to compel if that's the route you want to go. What I always tell everybody, though, if you're going to go the private arbitration route, you need to be prepared to litigate there in the event that the creditor follows you in. So, all right, let's see right here. One last one from the comments said, what can I do if a collection agency is still sending letters for payment after filing for bankruptcy? This can be crazy frustrating. You go through the bankruptcy process, you take the hit to the credit. The whole thing is to get rid of the debt and have it be gone forever. And then you get your bankruptcy discharge, which is the final order that's signed by your judge that says your debts are gone, your case is closed. You get that, and then all of a sudden you're getting a letter from a collection agency or from a creditor. Now, I should tell you this. I've been doing bankruptcy over 20 years. This is rare. We don't see a lot of it. But if it does happen, it's a problem. It's a problem not only because it's stressing you out and because it's causing problems for you, but the discharge order is a court order from a federal judge that says, creditors, this is done. Not only does it eliminate the debt, it bars them from ever trying to collect on the debt. And so if you have if you've received a discharge in bankruptcy, a creditor still sending you collection letters, if you had an attorney, talk to them. I have people years after the fact reach out to me and say, hey, so-and-so reached out to me. Usually the attorney will go out. I usually do, I say a shot across the bow. We'll say, look, we're going to give you the benefit of the doubt. This may have been a mistake. You may not have proper notice or whatever, but you need to stop. If they don't do it, then you can actually take them into the court and seek to hold them in contempt for violating the court order, the court discharge order that tells them to stop collection on it. So, all right, let's see here. Let's jump into some of the questions. I saw Destin was here nice and early. Destin says, I live in Yavapai County, Arizona. If a creditor uses alternative service, what method are they likely to use and how can I find out? So what alternative service, in particularly in Arizona, Yavapai County is in Arizona. What happens here is so they file their lawsuit and then the court gives them a window of time, 90 days, 120 days to go and serve you with the complaint and the summons. Service typically requires them coming to your house and literally knocking on the door and putting it in your hand. If they don't do that, or if they can't get you home, if you live in a gated community, if they don't have the right address, they can go to the court and they can file a motion for alternative service. They can ask for permission to serve you through an alternative method where they want to either mail it to you. I've seen recently email. I can tell you in the old days, they put them in the classified section of some, small little teeny newspaper in Casa Grande, Arizona, and nobody ever saw it. I don't see that was called a service by publication. We don't see that very often, mostly because newspapers have largely disappeared in the state of Arizona. How I see it typically now is the court requires them to send a copy to the last known address, certified, and then to tape a copy to the door of the last known address, which is all fine and good, but I can tell you a lot of times people don't see it. The wind blows, maybe they have the wrong address. They don't require them to send it to where you live, just your last known address. We see this particularly in eviction proceedings. I've never understood that when they allow alternative service, when they know the person doesn't live there because they were evicted. So, but those are the typical way I see it is through the mail. I have seen it, like I said, recently, email, where they have a confirmed email address and the court feels comfortable with that. So what I would tell you, you can actually go to the court. These documents that are being submitted to the court, they are public record, and you don't have to, you go and getting a copy from the clerk of the court, that does not count as service. So you can go and get a copy of the alternative service order is what it would be called. And it's going to lay out there in very specific language what the plaintiff or the creditor has to do to serve you. So that's what they're going to do there is check that out. So, and by the way, one thing I didn't mention, if you're looking in the comments section, I do have my Consumer Warrior tutorials. And then one of our great sponsors of our weekly live stream, Solo Suit. I'm actually doing another live stream with Solo Suit with their founder, George Simon, next Wednesday, the 24th. I'll put a link to it. That's always fun, where we can talk about and kind of show you what Solo Suit is. But I put those links in the chat section if you want to go ahead and check those out. So, all right, let's see here. See what Vicky has to say from upstate New York. I got sued by MCM. It's Midland Credit Management in, I'm going to say it wrong, Rensselaer, New York. The bill was time barred. Made a complaint with the Attorney General, had the index number back to February 27th. This is what we see. It was only $800. I'm a retired, disabled. My husband retired. It's from 2018. So I can tell you that. So the $800 lawsuits, something that's kind of interesting about debt collection lawsuits that I see is that you would think, I've seen them as low as like $450, which is insane because the filing fee in Arizona is like $150. The service fee is at least $100. And so they're spending more to litigate than they're actually owed. And part of the reason why is because usually in disputes where it's over a credit card, where there's a contract involved, they can ask for attorney's fees and court costs in the judgment. And then, it's like I've said 1,000 times on the channel, 95% of cases end in a default of debt collection cases. And so they'll be able to turn that $800 judgment into something that's like $4,500 kind of thing. But something to be aware of, is you would think that the little lawsuits are like, what are they doing? Not only can they add additional stuff on, but they also know, if someone owes $150,000 credit card debt and they file suit, they know that usually results in someone filing for bankruptcy. You don't settle out your 150,000 thing by coming up with 90 grand or something. That just typically doesn't happen. And so they know that the bigger suits, they're much more likely to get someone filing a bankruptcy. Nobody files bankruptcy over $800. So that's kind of a good kind of lesson to understand there as far as how that works. So, all right, let's see here. This person, 87 Gavinci, says, what's a good way to negotiate during mediation? So the mediation process, typically it's done, there's two, like in Arizona, they can do it through the court system, where they assign a mediator. Sometimes in the court system here in Arizona, they call them settlement conferences, or you can actually hire a private mediator. Private mediators, this is what they do for a living, is they're there to kind of broker a deal between the parties. Usually how most mediations play out, they will separate the parties into two separate rooms, and then the mediator will go back and forth between the parties and try to negotiate a deal. Something that's kind of bizarre here in Arizona post-COVID is a lot of the courts are doing the mediations via telephone. Not effective. It's not effective. I guess none of us are getting COVID, but it's not effective. I always say that mediation, the reason why mediation tends to work and result in some type of resolution is because it's equally inconvenient to all parties. I've been in mediations that have gone all day long, and by the end of it, the parties are just like, I don't care what I have to pay, just get me out of here. And so, but the mediator will go back and forth. Typically what they're going to do, if you're the defendant, the mediator will go to you and say, okay, here is the facts of the case. Do you want to present some type of offer? Now, it's important to know, because you're going back and forth, you don't want to start with your highest and best offer. And you need to give it some thought before you get into the mediation. Is there an amount that you would be willing to pay to get this lawsuit over with? I always say, look, there's no harm in negotiating. I think settlement is a good option. If you go to trial, whether it's a bench trial or a jury trial, you're in a situation there where you're giving up all power as far as how the case is going to be resolved to somebody else, because a judge or a jury is going to decide it. If you want to retain some control, you can come up with something that would work for you, and maybe something that you want to share with the mediator as far as why, the settlement is that, you may say, look, like this last person, I'm on Social Security. Social Security is exempt. They're not going to get anything from me, even if they win. And then the mediator can go over to the creditor, and they can talk to them and try to see if they can get something in place. I can tell you this: when you go to mediation, the thing is you need to understand the mediator's job. They're kind of devil's advocate for both sides. they're going to come to you and they're going to twist some arms saying, you need to get this thing done. And they're going to go over to the creditor and say, you got to get this thing done. They're on Social Security. They're not going to be able to pay. And they're going to do that kind of thing back and forth to get a deal in place. So that's kind of what I expect, is to kind of have a thought process and a plan in place as far as what you can actually pay and what you're willing to pay, so that if you do get a good deal, you can get it squared away. So, all right, let's see here. How do I fight an HOA judgment? HOA, homeowners associations. The HOA judgments, depending on your state. So HOA laws are very state specific, and more importantly, they are very contract driven. When you buy a house, there's typically these CC&Rs, and the CC&Rs are the contract between you and the homeowners association. In a state like Arizona, it's nuts. I can tell you, I don't take on HOA cases anymore. The law is so stacked in their favor that it's very difficult. Now, if they have a judgment, if they sued you, my advice is to just get that thing settled. And usually settlement needs to happen quickly, because they can usually ask and attach attorney's fees onto the judgment, even onto the lawsuit, onto the unpaid assessments. And the longer this goes on, those law firms are billing you for every phone call, every email, every court appearance. If they're thinking about your case in the shower, you're going to get a bill for it. My recommendation with HOA cases is get those things settled, because usually with the homeowners association, if you're delinquent, even without a judgment, it attaches as a lien against your home, and they can and do foreclose on houses to try to get those things paid. So HOAs, that's a whole different ballgame than debt buyers and credit cards. I would just recommend figuring out a way to get that caught up as quickly as you can. All right. Dark Emperor says, if I make contributions to my solo Roth IRA 401k plan that are above what my net income is for a given tax year, would a bankruptcy trustee have authority to undo those contributions? So I can tell you that typically contributions to a retirement account, they're exempt. 401ks, IRAs, in bankruptcy under federal law, they're exempt. There can be certain state provisions you have to be careful of. I know, again, in Arizona, where I practice, Arizona has a statute that says that contributions to a retirement account within 120 days prior to the filing of the bankruptcy are not exempt. However, there was some federal case law that said that's all good and fine, Arizona, but the federal bankruptcy exemptions exempt those, and they don't have that 120-day limitation. Federal law trumps state law, and so now in Arizona, at least, you can contribute right up until the day you file, essentially. So that's something you'd want to talk to an attorney in your specific state. And I didn't give my disclaimer that this isn't legal advice here in Arizona. For me, if you need an attorney, you need to talk to someone, particularly if you're not in Arizona. If you're in Arizona, my little phone number and website stuff is there. I'm happy to talk with you. But for something like this, I would definitely meet with an attorney just to go over specifically if there's any state protections or exemptions, that kind of thing. All right, let's see here. Joshua Libby Trucker says, love your videos. Thank you. I currently am in the process of settling 9 credit cards totaling about $30,000 in debt. I rejected my first settlement offer because it was so bad. Is that a bad idea? No, you never get the best offer the first time around. It's kind of like the mediation I talked about. It's kind of this game. So I've tried to figure out ways to avoid the game, but there's always some back and forth that you're going to have in trying to settle. The one thing I do recommend, if you're trying to negotiate, is your job is you need to paint a picture to the creditor or their attorney, whoever you're sending to, saying, this is as good as it's going to get. And here's why. I'm on Social Security. I don't own any real estate. I'm unemployed, or I'm underemployed, or I'm already being garnished, or I owe some tax debt, or I have alimony or child support. Whatever it is, these things that can kind of make them see, look, this is going to be hard to collect against. We better just get this thing resolved. And then when you go back with your initial offer and they come back with something stupid, you may come back with something higher, but maybe you're just coming up just a little bit, instead of trying to meet in the middle right from the beginning. But you've got to come in with some information, some facts that would make them realize, hey, they better take less. It's important to know too, with a lot of the larger debt buyers and debt collection people, you've got to understand they have a lot of information on you already. They're going to have information on assets as far as like real estate, often vehicles, sometimes employment. I've had situations where clients tell me, oh, I don't have any real estate. And then I go negotiate and I put in there, though, they don't have any real estate. And they're like, oh, yeah, look at our report. This guy owns 3 vacation homes. Don't do that, because then you lose credibility with your attorney and you lose credibility with the other side. And it's tough to kind of regain that in putting it all together. So, all right, let's see here. Shaka, thank you. It's good to see you again. I have to appeal my case. The judge did not want to hear anything about the completeness doctrine, 803.6, not being able to cross-examine a piece of paper, anything. The bill of sale was sufficient. So, and you know what? You do run into this, and I'm going to throw it out there. Self-represented people, we call them pro per, litigants who are representing themselves. A lot of times it's going to be more difficult. An appeal may be the way to do it. And the reason why is so to understand how appeals work. A trial court judge, they're there processing it. They're doing what they're doing, and they're pushing these things through, and they've got 1,000 other cases they have to deal with. When you appeal in a case, in most situations, you file a brief. The other side files a brief. And in most cases, particularly debt collection cases, there's probably not going to be like oral argument or anything. But the Court of Appeals, no matter what level it is or what state you're in, their job is not to retry the case. Their job is to look and see, did the judge make any mistakes as far as applying the law? Now, in a situation like this, these are all legal evidentiary issues. These are the types of issues that Court of Appeals, they do take on and that they do look at to see if there's been a mistake made. So the completeness doctrine, if the creditor comes in and they want to just admit exhibit A of a giant stack of documents, I always object. You can't just take one little piece of paper out and say, Judge, take a look at that one. You got to prove it the whole document. You got to have some context. Rule 106, completeness doctrine. We got to have it. And if you objected, or you raised that issue, then the Court of Appeals can look at it. 803.6, the business records exception to the hearsay rule. If their witness wasn't able to lay the appropriate foundation, if they weren't able to say how the original creditor created and maintained the documents, how it was stored, that kind of stuff, that's a very good issue for appeal. And then the hearsay, if they're allowing affidavits in, that unless there's a specific rule in your jurisdiction, like in Arizona, there is not when it comes to trial for allowing it. A written affidavit, it's a sworn out of court statement. It literally is like the definition of hearsay. And so it's something where those are the types of things to appeal. The thing I would tell you, Shaka, is that it's something you have to, filing your notice of appeal, it's just a 1-page document that you file with the court in most jurisdictions. It's got to be on time. Can't be late. Can't be 1 minute late, or you're going to lose that right to appeal altogether. So, all right, let's see here. Do this follow-up here. So, I guess the last thing I would like to know is if they know I'm lying and keep rejecting the settlement offers, can they just say, screw this and sue me? Yeah, they can. But if you don't do anything, they're going to sue you anyway. So I would keep pressing it. And not only that, so I like sometimes to have the particularly if it's being done via email, I would keep notes about the settlement discussions. A lot of times I'll see this where people are disputing accounts, they're submitting settlement offers, they're trying to resolve it. And then the creditor files a complaint and they're using just their template form complaint. And they're like, they haven't even made any attempt, or, it's one of those things where you can use that to your benefit down the road, particularly if you're to lose a trial and they come in and want attorney's fees. First thing I do is bring in the settlement discussions at that point. Say, Judge, we tried to settle this months ago and they told us to pound sand. And so, the only reason why they pushed it forward is to get attorney's fees. And the courts often don't like that. And that's sort of something you can use to your advantage to try to get those things thrown out. So, all right, we're about a half hour into this. I think we're going to close this out for tonight. Thank you, everybody, for tuning in. Check us out next week. I'll put a link to the one where George Simon and I from Solo Suit, we're going to be doing a live Q&A like this. I can talk about some of the things that they do. Check out some of my Consumer Warrior University, some of those things. I know they can be very helpful. And with that,